All right, folks, buckle up. We're diving into State versus Luis Beltron, a high-stakes felony case in Bexar County. Balanced scale from legal motions to jurisdiction debates. This one's a real courtroom roller coaster. Stay tuned to see if the defense can shake the court's authority.
In 2024 CR 4295, State versus Luis Beltron. Can I have parties approach and announce for the record? All right, and are you Mr. Beltron? All right, and defense, you said you've adopted his motion?
Yes, Your Honor.
All right, so the first motion is a motion for a special appearance. Under the authority of Texas Rules of Civil Procedure 120A for the divine purpose of objecting to the de facto district court's abstract subject matter jurisdiction, non-ex parte third-party waivers allowed. So let's address that motion.
Yes, Your Honor. My client's position is that he has been, that there is a defect in the abstract subject matter jurisdiction, that he has been brought into this improperly, because the state would be...
Studio microphone. Here's a key moment. The defense challenges subject matter jurisdiction. Police Scarlight translation for everyone else. They're basically saying this court doesn't even have the power to try this case. The judge? Not buying it. Watch closely, as jurisdiction is the first domino in any criminal case. It sets the stage for everything else.
Plaintiff, and they brought him in and are litigating that, and that there's a jurisdictional issue. The court does not have in persona or subject matter jurisdiction.
All right, is there a response date?
Judge, as is no objection for the court does have jurisdiction to reside in has been charged by indictment with the offense of aggravated robbery, and that is in the county practice, and so the court changed jurisdiction over those pieces.
All right, so Mr. Beltran, anytime that there is a criminal case that's deemed by the penal code to be a felony, then that comes to a felony criminal court. All right, and then the next question becomes whether or not a grand jury has been given evidence. You've been indicted, so they've been presented with information, right? And if it's alleged that the incident occurred in Bexar County and it's a felony, then I would have jurisdiction over the case. So if for some reason this was a case that is alleged to have happened in another county, let's say Hays County or Harris County, then I wouldn't have any jurisdiction. But do you understand? Mm-hmm. All right. So with this case, I'm not taking any of it to be true, because I have to wait till evidence is presented to me. But looking on the face of the indictment, and I'm sure your attorney will tell you, an indictment is not evidence of guilt. It's just the means whereby a person is held over for a trial, right? So when a grand jury indicts a case, they're just saying there's enough evidence to hold you over for trial. They're not saying it's evidence beyond a reasonable doubt. And when information is taken to the grand jury, or evidence, police reports, or whatever it may be, and it has to be allegations that it happened in county, and it has to be allegations that it's felony.
Studio microphone. Important courtroom tip. An indictment is not proof of guilt. Balance scale, think of it as the grand jury saying, there's enough here to go to trial. The judge is walking Beltron through the basics. The state has to prove every element beyond a reasonable doubt. This is where legal literacy can save your life in court.
Now, if this were not alleged to be felony, then it wouldn't be in this court. Even though it would be a criminal case, it would be sent to a misdemeanor court maybe, or perhaps even a municipal court. But because aggravated robbery, according to the penal code, is a felony, it's supposed to be in a felony court. And then if they're saying it happened in Bexar County, then it would come to a felony district court, state district court in Bexar County. And that's where we are. You understand? Is there anything you not understand about my ruling on that? All right, thank you. And then we have...
Yes. Excuse me, did the court take judicial notice of the indictment in this case?
Yes.
Thank you. Yes. Yeah.
The next we have new discovery of ex parte corpus trust fraud upon the court that conceals the facts that the charging instrument lacks subject matter controversy. No injury in fact exists.
Your Honor, I believe what my client meant by that is just kind of coupled with the first paragraph that the court does his position with the court didn't have jurisdiction. The court ruled they did. That then the indictment would not be uh, valid in this case. So I think that's what the client is trying to say.
All right.
Did I get that right? Okay.
All right. So, State, you want to address the issue and what I've, and if I'm interpreting this incorrectly, let me know, okay? So, you are saying that the offense, that there is no subject matter jurisdiction because there's no injury by any party? All right. So, if you can address that.
Your Honor, the case was presented to a grand jury that was duly impaneled. The indictment became a determined true bill of indictment. The indictment does comply with the penal code and the code of criminal procedure, which governs in this case, and does allege the requisite elements for the aggravated robbery. So it's a threat by using a deadly weapon, and so that is the harm. The crime was committed against the peace and dignity of the state, and there is an alleged complaint.
All right. So, Mr. Beltron, do you understand with the charge of an aggravated robbery case, sometimes it's alleged that a person maybe pulled a knife on somebody and said, "Give me your money," right? I don't know any of the facts about your case. The only thing I can do is look at the indictment, right? And then sometimes it's alleged that somebody pointed a gun at somebody and said, "Give me your money." The way indictments work is if it is a crime in the penal code, and there's a list in the penal code of all the crimes, and aggravated robbery is one of those crimes that's listed in the penal code, and it sets out what the elements are of it. Now, you're saying that there was no injury in fact exists. The only thing the state has to do is prove the elements that are in the indictment, and the indictment has to show the offense that is in the penal code. You understand? So, do you understand? Do you have any questions about the court's ruling? All right. If there's something you don't understand, let me know. All right. And I understand that sometimes when people have been to law school, like for example, I haven't really worked on cars, so there's a little stuff I can tell you about being a mechanic, but I really don't know the ins and outs of a vehicle. You understand? All right. So number 3, defendant is erroneously charged with an abstract offense. C, I don't know, I can't read that word. Something taxation. District court is criminally attempting to receive an unauthorized, colorable, no fault immunity third party benefit in violation of the 7th Amendment. All right, do you want to address that, counsel?
Yes, I believe my client. I think it just goes back to being a third party brought in here without abstract subject matter jurisdiction, and the fact that he was brought into this. I believe that's it. Is that it?
All right. State, do you want to respond?
Judge, regarding, I guess, the 7th Amendment applying in the case. Okay.
Yes.
That is civil suit, in a criminal court until
All right. So the 7th Amendment applies to jury trials that you're entitled to, and that is in federal civil cases. Here, You do have a right to a jury trial if you want a jury trial. And if you want a jury trial, I'm going to make sure that you have a jury trial, okay? And then the other issue, I don't understand when you say, explain it to me, you're saying district court is criminally attempting to receive an unauthorized, colorable, no-fault immunity. What do you mean by that? Because what I can tell you is I don't receive anything related to these cases. Of course, as a judge, I'm paid a salary for the work that I do, but I don't receive any funding or extra funding based upon how I resolve cases. Do you understand? Do you have any question about that?
Sure.
All right. So then the other one is dishonest services that rises to constitutional tort and national security concerns, communist activity detected in violation of Title 50 U.S.C.S. 841. This court now under federal questioning under Title 28 U.S.C. 1331, light of new evidence investigation hypothetical claims. All right. Defense.
I'm not sure what my client means by that. To explain it.
All right. If you could explain that to me, Mr. Beltron.
That's what I'm trying to say. Change it. Once I press positive, which like that party,
Okay.
I'm not. Well, I don't. That party, I'm not sure how that works. She was using a most criminal law, but I know that. How they contact us and see that.
So let me explain something to you. Whenever you see cases on the criminal side, it's not individuals versus individual. Usually when you're on the civil side, if it's a marriage, it's individual. If it's civil. All right, here, the reason why it's the state of Texas is because in criminal court, it's not you versus the complainant. Whoever the complainant is in this case that you're accused of committing aggravated robbery against, yes, it's alleged to have happened that you committed aggravated robbery against. But the state of Texas, the way we were taught in law school, the state of Texas takes offense, right?
Studio microphone. Now, this is fascinating. Beltron's confused about cross-examining the state of Texas. Eyes quick law school refresher. Criminal cases equal state prosecutes, not private citizens. It's an offense against the state itself, not just the victim. Classical building this distinction blows a lot of people's minds, but it's critical for understanding how defense strategy works.
The state necessarily is not the complainant. They're just bringing the suit or the case because the state of Texas is offended that an offense is alleged to have been committed within the state of Texas, within the county of Boone. So that's why the state of Texas is listed and not complainant. Do you understand?
Yes, I understand. And so, how do I cross-examine the state of Texas?
The state of Texas, you don't cross-examine them. The persons you would cross-examine would be any witnesses the state of Texas would call to try to prove that you've committed an offense against the sensibilities of the state of Texas. So, for example, for an aggravated robbery, they'll need to call somebody to prove that it happened in Bexar County.
Studio microphone. Here's a classic courtroom teachable moment, double jeopardy. Locked judge explains it clearly. If you've already been tried and found not guilty, the state cannot retry you. Simple in concept, but it's a powerful tool for any defense attorney. Beltron? He's learning fast that legal jargon is more than just fancy words. It's protection.
They'll need to call somebody to prove that it happened on or about whatever date it is. If there's a weapon used, they'll need to call somebody to prove that a weapon was used. And they may need to call a complainant to say, hey, I'm the person in your indictment. You understand? All right. Do you have any questions or any information? All right.
May I ask my client a question before you go on to this? Are there any other things in here? Some of it is repeat stuff. Were those the main points? Or is there anything else in your motion that are different that we need to bring to the court's attention that's different?
All right. So then with regards to that motion that's combined from page 1 to page 6, then the ex parte relief requested will be denied. Now, by denying that, that doesn't mean that if there's a jury trial, your attorney still will not have the opportunity to question whatever witnesses they state calls. Okay? So that will be denied.
There was it appears to me that there was like 3 separate documents stapled together. That's the way it's supposed to see.
Yes.
There is the next one, which is exhausting administrative relief.
Okay.
My client is not wanting to have that like it deals with effective assistance.
Studio microphone. And here's where it gets real. The judge confirms Beltron has a right to a jury trial. Adult balance scale, whether bench or jury, each element of the crime.
Ineffective assistance of counsel. Right? Beltron, that's not to be heard right now.
All right. And let me explain something to you. I understand that's not to be heard right now, but what I can tell you is attorneys who are appointed to represent people, those are attorneys who are on the wheel for appointments, right? And if this is a first-degree felony, just from the face of what I'm looking at, and if Ms. Day wasn't qualified according to qualifications to be on the wheel for first-degree felonies, she would not have been appointed to represent you. Do you understand? Mm-hmm. And Ms. Gay, are you on the first-degree will?
Yes, I am.
All right.
So the next document is entitled Court's Constitutional Notice.
Mm-hmm.
And that addresses antitrust violations, brought upon the courts, actions of the state bar.
All right. Do you want to take these one at a time, counsel?
I guess so, Your Honor.
All right. The first is new discovery of antitrust violation lies brought upon the court, elected state bar officials, seditious organization, conspiring to fraudulently conceal the ultimate fact, Sixth Amendment misconduct, that the State Bar of Texas lacks capacity to prosecute.
Oh shit! Here we go again.
A natural person. It is an improper plaintiff. All right. So with that, I can tell you, the State Bar of Texas is not prosecuted. State Bar of Texas is more of an affiliation that attorneys are required to belong to. And we actually have to pay State Bar dues every year. And when that comes around every year, everybody's like, oh my gosh, State Bar dues.
Do you know?
Yeah. So the State Bar is not participating in this trial. Now, I can tell you, as an attorney, your attorney as an attorney, the state as an attorney, anyone who's licensed in Texas, they're required to be a member of the State Bar of Texas. You have to pay dues to the State Bar of Texas. I think it's $265. It may have gone up. All right, so they're not going to be trying yet. All right, the next one is State Bar virtually gathered evidence, video, police reports, third party. Again, what I can tell you about that is the State Bar hasn't gathered any evidence. State. Yes. All right, so do you want that heard or no? All right, and then the next one is, so to permanently prevent a false State Bar, anything with regards to the State Bar, do you still want that heard or no? It says, Object to Texas State Bar ex parte matter waivers in fictional double jeopardy defective jurisdiction. Do you want that heard? All right. Defense?
My client believes that the court does not have jurisdiction, that he is concerned about his waiver of his constitutional rights. Some of it deals with what happens at trial, like you say, evidence being admissible, being admitted wrongfully, and that he still believes he's a third party, and that there's jurisdiction, and that the court doesn't have the power, I'm guessing, to rule on evidentiary issues such as 901, and that, in other words, probable cause is third party fabricated that secretly planted and dressed up to appear that it has merit, but it does not. So he is talking about what jurisdiction, and also trying to state his right to object to evidence.
All right. State, do you want to address that?
Regarding collection of evidence, I'm not sure.
Oh, no. So, let's address double jeopardy. Double jeopardy, defective jurisdiction. So, double jeopardy, if you have not been previously tried for the same offense before, that's what double jeopardy is. Basically, in a nutshell. There are certain exceptions to that, but when you mention double jeopardy is you've been tried for something before and you were found not guilty, right? And now the state is trying to try you for the same thing, even though you were previously found not guilty. Or either you had something that was dismissed with prejudice and they're coming back and trying to try you for the same offense. Do you understand? State. Has he been tried before for this same offense?
There are generally no actions on the indictment, that the indictment can be against him. As far as I know, he's not been charged with it. He should.
And there has never been anything pre-indictment that was dismissed prejudice with regard to these cases. All right. Does that address that issue for you? All right. Then the next one, deceitful corporate veil and trumped up judiciary immunities. Fatally peers. I do not forfeit my privileges and immunities under the 4th and 14th Amendment. What I can tell you is during a jury trial, when the state calls their witnesses, your attorney will have a chance to cross-examine those witnesses. The rules of evidence do apply. If she finds that there is some questioning that is objectionable and should not be answered, then she will stand up and make an objection. Normally the objections may be hearsay, entering the province of the jury, assuming facts not in evidence, could be relevancy, could be 404B, could be any of a number of objections that she can make. Once she makes those objections, I will make a ruling, and my ruling will decide whether or not the witness can answer that question and whether or not the jury can consider. Do you understand? All right, does that address that issue?
I think the other issues deal on the second page, deal with State Bar, and I think the courts address that.
Okay.